seated. Good morning. We are here in Yellow Corporation, which is case number 23-11069. Ms. Jones, good morning.
Good morning, Your Honor. Good seeing you. Your Honor, for the record, Laura Davis Jones of Pacholsky, Stang, Zeal and Jones on behalf of Yellow Corporation. Your Honor, I think we have a very short agenda for you today. You should have in front of you the amended notice of agenda.
I do, thank you.
Your Honor, matters 1 through 20 have either been continued or resolved. Matter 21, I think Mr. McGutcheon has a few things to say about that. Matter 22, Your Honor, I think has come off calendar, or at least informally. So, Your Honor, with that, I'm going to yield to Mr. McGutcheon to give Your Honor an update on where we are, and then we can talk about the calendar.
Okay, very well, thank you.
Thank you.
Morning, Your Honor. Casey McGushin from Kirkland & Ellis on behalf of the debtors.
Good morning.
As Ms. Jones referenced, even though there's a 14-page agenda here, there's not actually that much left. So I did want to give Your Honor some context for sort of what's been going on in the background, understanding that the things left on the calendar are lift-stay motions, which are not formally, obviously, the debtors' motions. So over the last several weeks, the debtors have been receiving a number of requests to lift the stay and allow litigation in state and federal courts to proceed, and those have continued to come in, up through late last week. A central argument of several of those lift-stay motions is that effectively there won't be any harm to the debtors from allowing those cases to proceed because the defense costs and any judgments will be borne by insurers. And the debtors have a number of potentially applicable insurance policies, and we've been in discussions with one of our primary insurers, Old Republic Insurance Company, or ORIC. To date, ORIC has not agreed that any of the underlying claims are covered by the insurance policies. ORIC is holding a little over $230 million in collateral from the debtors, and the debtors have been in discussions with ORIC about coverage for those claims and the holding of that collateral. At the end of the day, it may be necessary for the debtors to litigate with ORIC over this coverage. Nobody wants that. What we've spent the last weeks doing is talking with ORIC to try to avoid that outcome. Late last week, in our discussions with ORIC, we came upon, started discussing a potential process using alternative dispute resolution processes to try to avoid the need for some of this litigation. And we're very early in those discussions, but generally what we're talking with them about is to the extent that plaintiffs in cases outside of the bankruptcy court want to lift the automatic stay to proceed, we would set up some sort of ADR process to allow both ADR for the underlying claims and potentially ADR related to coverage issues. And the idea is, let's try to avoid any unnecessary expense for these claims going on in state court while also addressing potential coverage concerns. And if the ADR process was ultimately unsuccessful, these plaintiffs could waive claims against the estate and proceed in state court with ORIC or any other insurer reserving its rights as to coverage. So that's...
Mr. McCutcheon, just if I follow, are you talking about doing something like this under a plan or by motion, or what's contemplated?
Yeah, so I think the exact process by which we would present to the court, I don't think has been contemplated yet.
Okay. That's a fair answer.
Yeah, it's a question of timing and sort of where we are in the case, when all this comes to a head. And just to be candid, we are very early in our discussions with ORIC about this process. But once we started having these discussions with ORIC and sort of getting around this potential process, we started reaching out to a number of the lift-stay plaintiffs who had their motions up for today. Ultimately, by Saturday morning, we were able to reach agreement with all but 2 of the lift-stay plaintiffs, as Ms. Jones referenced. Last night and this morning, we reached resolution with 1 more. So there is only, as far as I'm aware, 1 lift-stay plaintiff who is still up on the calendar today. So the debtors are prepared to go forward on that motion today. My understanding from discussions with counsel is that they did not expect this to be a substantive hearing on their motion. They intended it to be more in the way of a status conference, but I'll certainly let them speak for themselves on that point. And at this point, unless the court has any questions, I'm happy to cede the podium and then I can
Okay.
respond to arguments.
Okay, no, that explanation was helpful. I'm happy to hear from the move-in. So thank you, Mr. McCutcheon. Mr. Rosner, good morning.
Good morning, Your Honor. For the record, Fred Rosner, Rosner Law Group, and I'll try to keep my remarks brief. We did specifically notice this for a preliminary hearing consistent with the local rules, not that we were going to go forward on the merits today. So we just want to check in with the court and basically introduce ourselves and talk generally about what we are planning to do. Again, I represent, as bankruptcy counsel, Donna Doherty individually and as administratrix of the estate of her late husband, Norman Doherty. I'm co-counsel with Chuck Dorr of the Charles E. Dorr PC law firm, and Ms. Doherty is a plaintiff in a wrongful death action against debtor YRC Inc. That action is pending in the United States District Court for the Northern District of Georgia. Significantly in that action, as I understand it, we have demanded a jury trial, as is our constitutional right, and the procedural posture of the case, as I'm advised, is trial ready. So that was stopped when the debtors filed their Chapter 11 bankruptcy before this court, and we filed the motion to return to the district court in Georgia to appear before a jury of our peers and seek to liquidate our claim against the debtor and pursue our claim as a claimant in this case, and also pursue our third-party rights. We are troubled.
Third-party rights meaning you have claims against non-debtors?
No, yes, insurance.
Okay, but the insurance is only derivative, right? You don't have a direct claim against the insurer.
Yes, I stay. I always learn something. So yes, exactly what the court said.
Okay.
Yes. So we are troubled by what we hear that Old Republic Orc has taken the position they can draw down on the letters of credit and then deny coverage. So we intend to propound discovery with the debtor and with ORC, seeking to develop our record to allow us to lift the stay and move and go back to the District Court of Georgia. So that is where we are, and I did have a conversation with the Kirkland and Ellis attorney, I think, sometime in the past few days. He was kind enough to send some of the documents over. So we're reviewing the policy, and we certainly are looking at the form MCS 90, and we're going to explore what our rights are under that. But we don't agree that at the end of the day that ORC's position is tenable, either as a matter of the contracts or a matter of public policy when your insured becomes insolvent. So I think we are going to pursue our rights, and I'm somewhat heartened in what the attorney for debtor just said, that there might be an opt-out from the ADR. So we want to be able to preserve that right to go back and present our case not to a mediator, but to a jury of our peers to liquidate the claim.
Okay.
I think with that, I'll probably just pause and ask if the court has any questions.
I don't. I mean, all these issues are interesting, but since none of them is presented to me today, I'll resist the temptation to start spouting out what I think about them. So I'm happy to let the parties continue their discussions, and when there's a ripe dispute, do my best to get it right.
Thank you.
Okay, thank you.
Your Honor, again, Casey McGushin from Kirkland and Ellis on behalf of the debtors. As Your Honor noted, none of this is particularly ripe. We don't have an ADR process to present to you at this point. Obviously, everyone will have the right to object to whatever we propose to Your Honor, and everybody's rights are preserved. If Your Honor has any questions, happy to answer them. Otherwise, of course, we're going to, we'll deal with discovery as needed and keep progressing all these issues forward.
Okay. I don't have questions at this time. Obviously, to the extent the parties are talking and trying to work to something that's consensual, that's terrific. To the extent there's a motion that's brought to me that I've got to decide, I'm happy to do that. But it seems to me, in the meantime, what I should do is stay out of the way and let the parties continue their discussions.
I feel footsteps behind me.
Yeah,
So
Mr. Clatter.
Good morning, Your Honor. David Clauder on behalf of Old Republic Insurance Company. With me in the court is my co-counsel, Kenneth Thomas. from Fox Swaddle in Chicago. Mr. Thomas has been admitted pro hoc vice and would like to address the court on
Certainly.
behalf of Old Republic.
Okay, very well, thank you. Mr. Thomas.
Good morning, Your Honor. Ken Thomas, Fox Swaddle 11 Carroll, on behalf of Old Republic. As the debtors have laid out, we continue to engage in conversations about an ADR process, and so I won't tread more ground on that front. I just wanted to make sure that a couple of things that the record was clear, because I've heard a couple of things represented, and I want to make sure that our position is represented properly. Old Republic has not denied coverage. We've issued reservation of rights, and as you know, Your Honor, as laid out in our omnibus objection, the coverage is a fully fronting indemnity policy, so it's not your typical liability, auto liability, insurance policy. And so we've issued reservation of rights.
So I read your paper, and I confess I know just enough about insurance to be dangerous, but I was interested in understanding at some point, and while you're here, this is as good a time as any, understanding more about how this coverage works. If you could just explain it in terms that someone who's not really an insurance lawyer can understand, that would be constructive.
Yeah, so as you noted, Judge, I am a bankruptcy lawyer, so I rely heavily on our coverage lawyers to understand how it works. But the fully fronted indemnity policy coverage, which was covered by around $230 million of letters of credit, is not just auto. It's not auto. It's also workers' comp, and there's some general property liability coverage. So there's a couple of different buckets over that course. And under that policy, there's a $6 million retention, which equals the limits of liability, and it's a dollar-for-dollar drawdown on the limits of liability for every dollar that the debtors pay on that retention. And so the policy also includes an MCS 90 endorsement, which is obviously subject to lots of law about how that applies. So that's just sort of a general overview of the policy.
Okay.
But just wanted to make the point that the $230 million of letter of credit proceeds was applicable to the auto, the workers' comp, and some general liability property, not just auto. So only a portion of that is the auto. And that we've issued reservation of rights. And we have not denied coverage, but whether coverage applies will be a case-by-case basis. And really, the debtors have been responsible for handling these claims. We've taken the position that we don't have a duty to defend, and the way it worked prior to bankruptcy is that the debtors were in the weeds as far as defending these claims and the facts. So Old Republic is really just getting up to speed as to what the facts of these cases are to understand how they would operate under our policy.
Okay, so it's a $6 million policy with a $6 million self-insured retention. So does that mean that the debtor pays $6 million before $1 of coverage kicks in, or just how does this? What's the mechanic of how the relationship between the available coverage and the SIR?
Right. So again, I'm not a coverage lawyer, so
okay.
I'll do my best. But as far as the retention, the way the policy is supposed to work is that it's indemnity. So the debtors would pay, and then basically it would be a dollar-for-dollar drawdown on the limits of liability up to the limit.
I see. So they pay $6 million themselves and then can seek indemnity, and it indemnifies them for both defense costs and underlying liability. So they can spend up to $6 million of their own money. They're up front, not you. And once they've spent whatever they've spent up to $6 million, they can turn to you and say, "Can you cut me a check, please, for the $6 million I've spent?"
So I will stop myself from making any further because I want to make sure that.
Okay, that's fair enough. And look, this isn't in front of me now. I was just when I read your papers, I didn't fully wrap my brain around how it works, and it's not necessary that I understand it fully today. So we'll leave my state of knowledge where it is, and we'll learn more as necessary. So I appreciate your help.
Thank you, Judge.
Thank you, Mr. Thomas. Okay. Knowing a little bit is quite dangerous. That's about me, not counsel. Is there anything else that the court can do to be helpful to the parties while we're here today?
No, I think that's all we had, Your Honor.
Okay. Well, let me thank all of you for the reports. obviously appreciate the efforts by the parties to keep their conversations going, and to the extent those are successful, great, and to the extent they're unsuccessful, you all know how to find me. So with that, and my thanks for everyone's hard work, we're adjourned.